Whatever is
Yes, well,
Lordship, my commercial suit has been pending in the Bombay High Court, consistently adjourned. So I have filed a fresh SLP against the last order of 27th April, in which the judge had recused because my matter is not getting reassigned now. So,
go and tell the Chief Justice of the High Court, if you are learned judge,
Lordship, we have already filed two urgent precipices there.
it has become.
My Lord, it is not
want
for
us
this.
to run now every High Court affair.
My Lord, it is
Listen
not.
before Chief Justice of the High Court, please.
well, that passed.
Lordship will take care of.
My Lord, it is not for listing. Yesterday was the last day for filing written submission in Shabarimala matter. I may be permitted to file today, otherwise the registry won't accept it. Yesterday was the last day for filing the written submission in Shabarimala matter, my lords.
All right, you can do today.
Well, it's the order that we just passed upon, my lords. Well, it's para 3 at the top of page 2, my lords. The directions. Well, it's the directions of the National Green Tribunal.
The National Green Tribunal had been issued
were relied upon in a petition, well, it's instead of had been issued. Mine was a subsequent petition relying upon the earlier direction of it.
On the oral mentioning the matter is taken on board, the order dated para 3 of the order dated 22nd May 2026 in order to be.
My Lord, I want to draw
to the following extent.
Your Lordship.
Please allow us to correct one more small order. The last line of the para 3 of the order is ordered to be corrected, which shall now be read as follows. When says the directions of the National Green, the petitioner relied upon the directions said to have been issued by the National Green Tribunal.
Please, ma'am. Grateful. Keep you.
Your Lordship, I filed an application. I'm requesting for urging of the same. It is with respect to salaries and benefits of certain of the applicants. It may be listed this week or after the vacation, Your Lordship.
We'll see. Please send your memo explaining the reasons of urgency. We'll see what is good.
That's my colleague. May I just explain this matter? It relates to Mahesh Chandra Sharma case, and I am receiving 50% of the salaries. I'm representing government doctors, and I'm requesting this matter may be listed in July first week.
My Lord, may I draw
during partial working days.
I'm so sorry. The
on
first
opening.
week on opening. Yes.
On opening, no problem. Anyone asking to list the matter in August, September? All right, done. Your request is.
My Lord, may I draw a kind attention towards the matter, the cockroach issue. Even after the clarification of the Honorable Chief Justice of India, my Lord, a distorted and malicious narrative is being continued.
Don't take it so sentimentally.
Seniors of this Honorable Court had joined the hordes with them, my Lord.
Learn this lesson also.
Attempt to demolish the image of the institution, my Lord.
My Lords, I'm mentioning the same writ petition civil. In regard to it, we are praying that the oral exchange of the courtroom proceedings.
Just repeat again.
My Lords, I am mentioning a writ petition civil wherein we are praying that the oral exchange in the courtroom proceedings cannot be utilized for the commercial purposes. Other than that, we are also praying for the CBI probe in regard to the statement given by learned chairperson of the BCI that there is 35 to 40% fake degrees in the law.
We will see. Don't worry.
Your Lordship.
There is no such grave urgency in these matters. We will consider in due course of time.
Your Lordship, may kindly allow me to mention a transfer petition. The matter is listed before the trial court on 4th June, and the service is completed in the matter. We request that it kindly be listed before the ensuing summer vacation.
No. Before the trial court, it is listed on 4th June.
Yes, Your Lordship.
What is the matter coming before us here?
Your Lordship, it is a transfer petition. And for the petitioner wife and with a minor child.
Service is complete in this matter. In this transfer petition, service is complete, my Lord.
We will see. All right, thank you very much. Now start us some work also.
Wait, please, Your Lordship. I appear for the state of Madhya Pradesh.
Mr. Solicitor General, you see 2-3 aspects which were there. One was with respect to the second autopsy. That has been done. The High Court has done a commendable job. They passed an order. And as we could read, my brothers also read in the paper that now cremation has taken place.
Yes.
So that aspect is over. Now the other thing is that, and we appreciate the state's prompt action, they recommended for CBI investigation.
Yes.
anyone representing or Mr. Solicitor General, ask the CBI to take over the investigation.
My lord, I'll talk to, my lord, that,
Why we are saying,
consent was,
we are slightly at pains because some of these sections, and we will request our media friends also, please, that we will definitely request them that don't go for the statements of the victim's family or the other family. And let the things move in the, as per the law and procedure, the authorities, the investigating agency, they will follow, because otherwise statements are being recorded. And one section has started saying, because I think the mother-in-law happens to be a former district judge.
Yes.
Yes. Some of the, it's quite unfortunate that they started saying that judiciary is not permitting to have a fair trial.
Manoj, I am appearing for the
Anyway,
accused.
it is
I am appearing for the accused. My
mother-
entire 161 statement is in the papers today.
Mr. Dave, we don't want to cause aspersion against anyone.
Yes, my lords.
We have no reason to doubt that the victim side also will fully cooperate, the other side will also fully cooperate.
Jesus.
And we have no doubt on our state agencies also or on the CBI also.
Lordship, please.
That whosoever will investigate, they will definitely take the investigation to a logical conclusion. They
Impartial.
will reach out what is the truth. We are only because this kind of a narrative is being created.
Yes, I am obliged to.
Therefore, it is in the interest of all
Yes, my lord.
that we should expect that some independent agency should take over.
Lord, that would be done. May I only say one thing, my lord, why this has started? Lord, one of the potential accused, my lord, the learned former judge, my lord, has started giving interviews, hopping one channel to another, and my lord, almost maligning the deceased. Therefore, my lord, there is a reaction and counter reaction.
No, there will be no.
Never have happened. Only a minute, Mr. David.
No, there will be no. I am assuring you there will be nothing on instruction.
I appear for
There
the
will be no-
victim's family, will have something to say.
We are not
Second thing,
interested
Lord,
in the
with which
media.
the investigation is concerned. Lord, the FIR was registered, my lord, on 15th May. The concerned, my lord, potential accused, the mother-in-law, my lord, described her as mother-in-law, moves an anticipatory bail, my lord, on 14th of May. Hearing concludes and granted anticipatory bail on 15th of May. Lord, which is under challenge by, my lord, the victim as well as by the state government also. The difficulty is, Lord, despite our repeated request for her to come and get her statement recorded, Lord, there is no cooperation.
Well, it
Lord,
can't be
last-
said here.
Only a minute, Mr.
No, this is not fair,
Lord,
my lord.
this-
It can't be said here. at
Last,
this
Lord, we intimated her that we would come there and get your statement recorded. She said, no, I'll not get my statement recorded. We could, my lord, with difficulty, Lord, collect, my lord, or seize the mobile devices, etc. Lord, that's investigation is going on, my lord. I would not like to prejudice either of the sides.
statements
But there
have
is,
been
my lord,
recorded.
non-cooperation.
We have absolutely no doubt on the state police that they must be doing and they will continue to do it with complete fairness and impartial. And normally they do it in a very dispassionate manner. We, barring a few instances might have in the past as and when, but the correctional measures have already been, have always been taken wherever this kind of things have happened. In this case also, we do not want to demoralize the state police. They must be doing a very good job.
But in any case, now it's gone to CBI, my
Because
lord.
the state government has requested.
Yes, my lord,
They have requested.
so that there is no
Yes.
fingers, my lord, pointed out.
Section is very fair, completely above board, because the moment a narrative was created, they said, all right, you please don't doubt us. We have, our bona fides are very clear. We want to send.
And the mother-in-law statement was recorded, in fact. More than thrice it was recorded, the mother-in-law. All that can't be argued here, my lords, as far as the investigation to the prejudice.
Because once the state has recommended, in fact, we don't want to even issue a direction for that. There is no need to.
No, my lord, CBI would take over, my lord, but now state has,
And they should for it immediately.
I'll speak to the director, my lord.
But that will be appropriate, not because if the solicitor intervenes, not, otherwise today, not DOPT has to issue a notification under 6, not, that's not happened. So even though the state has done it, still the DOPT response can remain in limbo.
It's not as if the state has not done anything.
It gives consent and hands over the investigation. It's an administrative exercise between the state and the center.
That will
or
be-
rather the CBI under the DSP Act. So there is no question of judicial intervention here.
No, not judicial. What my learned friend perhaps says is that there is a ministry called Departmental of Personnel and Training, which is the, my lord, the nodal ministry for CBI. So they issue a notification based upon the consent of state
Correct,
government.
correct.
That's a formality. The lordships are right.
Yes, the state has,
To do it under
once the
5
state has consented and recommended, I think that
I'll
will be,
ensure that that happens today. My lord. I'll speak to the concern.
with the intervention of your good office, it will be expedited.
Definitely.
It shall be done.
I think there is no other issue
There are a
surviving.
couple of issues, Lord. Just kindly just take my note, Lord. I've tendered a note to your lordship. There are certain concerns which we have right now, which your lordship may consider, Lord. But kindly just come to the second page for a moment, Lord. The issue which your lordship will have to see, because this is an issue of institutional bias, so please see it. Kindly note, Lord, there is a 3-day delay in the FIR registration. There is a failure, according to us, to preserve the evidence because it was all
So,
open.
Luthra, all these issues, once the CBI takes over,
Why not-
then
not-
these
no,
are all
not-
matter
no,
of
not- not
investigation.
Till the CBI takes over, these will have to be addressed, Lord. Because each day, Lord, the evidence is likely to get lost. Kindly just see it for a moment. Number same, Lord. The mother of the
No, Luthra, we should be very clear.
Lord,
We will
may I
not-
suggest this?
But this is
May I
investigation.
suggest this?
We will not, we will ensure that one, that victim or whatever the unfortunate incident has taken place, it must be fairly and independently, impartially investigated. That's all. There were doubts. You were also going unnecessarily to media. The other side is also going to media.
Yes.
This is our request to you. Whatever statement you want to deposit, please make before
will not-
prescribed authority, that is the investigating agency.
Lordship, please.
That your statement recorded.
Yeah.
Our request to, we will, of course, we can't do anything, but we can only request media also, please don't go for recording statements of the victim's
Yes.
family or reducing their pain into sound bites, please. That's not the way anybody should do it.
Very
This is not-
grateful. Very grateful
Because
to your
this is a very unfortunate incident has taken place. Both sides are, might be.
It's not a subject matter which can be sensationalized. At the same time, it's because of, my lord, this media intervention that several things have taken place.
No, undoubtedly, they help a
That
lot.
whole also, my lord, is,
Our only concern is not to statements, because
yes.
what the statement they will make, where they will make, that creates problem.
Even the statement in the police custody is
It's
reported.
only because of they
Outside
highlighting
about.
that, after all, it came to our notice also only because of them.
Lord, in fact, our
Yes,
concern is.
yes.
Lord, our concern is not the CCTVs in the open domain. There are, the lady, the mother-in-law produces her own CDRs which have been flashed down. Not, these are not things which.
Yes, this is what precisely we are requesting both sides. We are requesting all of you, please do not make premature statements like this. In any case, there is a law prescribed mechanism of making statements, recording statements, follow that
Absolutely.
procedure.
Absolutely.
And there is already, the state police was already investigating.
Yes.
You can go, whatever statement you want to get recorded, please go there. Now that, maybe that during the course of time CBI takes over, you get your statement recorded
Let me
there.
just make one request, but I don't want to read it specifically, not just read point number D8, give him a copy.
I have a copy.
Point number D8, page number 3, Lord. I just want your lordship to see that for a moment. I don't want to read it. We are not here to sensationalize matters.
No, please don't, and we hope you note it's not circulated here. Our
It's only
Even we are hoping that.
different, Lord.
I don't want it. I don't want it. These are all his
I'm just,
allegations. I will
just
turn it
pointing
to
out.
him.
That's all I give you.
Mr.
My
Luthra
lord,
can
this,
keep. You can give it to the learned
These are-
This
solicitor.
is, my lord, in public domain, my lord.
Not
He-
this is, not this
he
is. an
is
issue in
something,
the
my lord.
public domain. This is something in the domain.
This is all in investigation.
I've limited my request only to Lord B, para B.
No, we will not take notice of anything, Mr. Luthra.
I'm obliged. I'm
That is
obliged.
very unfortunate that you want us to take all
No,
the.
but I
This
want
is
your
done
lordship.
by the investigating agency.
What I'm saying to your lordship is let them do this part. That's all. I'm not asking.
They will do it.
We appreciate your concern, that you had a very serious concern that you somehow or the other thought, and maybe some instances here and there that you thought that you are not getting a fair trial, investigation. That has been ensured now. State immediately promptly acted. They gave consent, they recommended. Now, it's only a procedural part, and with the,
May I just say this?
I have a lot of things to say in my defense also. I can produce all that this is not an offense.
A representation not based on this to the state. Let them look into all
Luthra,
this.
you, Do you, with your experience, do you recommend this kind of representation in these matters?
I'll tell your lordship why. I'll tell your lordship why I'm seeking this, not because there are certain materials which have not.
Unless you want something to be, of course, if you want certain things to be published, even
No, no,
before
I like,
No, no, Lord.
yes.
then it's a different issue.
I'm saying not, there are certain aspects which we believe not, which are not being taken note of or covered. So we'll inform we'll give them a point of view. They can act on that. It's not to be put in the.
No, only one, my lord, moral of the story, forgetting this for a while and without attributing motives to either of them. One thing is clear that the girl has lost her life, whether it's by suicide or by any other criminal act. My lord, it's always better for all parents.
Undoubtedly, she has died an unnatural death.
That, my lord,
What was the cause and all these things?
Lord, for parents, the moral is that it's better to have a divorced daughter than a dead one.
Absolutely.
When she is repeatedly saying that I am living in a hell, please save me,
The
please
kind
save
of
me.
pain and agony for parents,
Yes.
for close, near and dears, for family, and even for society also sometimes, it's something unbearable. There is no doubt about it. We all have sympathy with them. But then the law, there is a procedure followed.
Certainly, brother. No, I am not on the
Solicitor, the seriousness of the incident and the offense cannot be undermined.
Yes.
Very true.
Generally, my lord,
Natural death within 6 months.
Within a few months.
Within 6 months. What you are saying is a dragging of a matrimony in view of conventional feelings that marriage
that's
should
exactly
continue
what I'm grateful.
would have been understood if it dragged on for 2 years. But when it is within 6 months, even the reaction time will be something more than 6 months.
Correct. I'm saying in general for the parents that better to take that call immediately rather than losing the daughter.
I think not, it was just
Anyway, my lord, it was-
simply shocking. And yes.
So Ms. Twisha Sharma, a 33-year-old person, former actor, unfortunately died an unnatural death at her matrimonial home in Bhopal on 12th May 2026. A news article published by India Today on 18th May 2026, followed by followed by several media reports. Were thereafter published alleging institutional bias and questioning the fairness and impartiality of the investigation which was being conducted by the state police. The reason as it was perceived for, the reason that was reported for the alleged lack of impartiality was that the husband of the deceased is a practicing lawyer and her mother-in-law is a retired district judge. That's program. It thus appears that the family members of the deceased questioned the response of the police authorities and alleged undue influence in the matter of investigation. A narrative was also created as if fair investigation was being denied on account of involvement of the judiciary. It is in this backdrop that these Motu proceedings have been initiated by us. That's program. Meanwhile, certain developments have taken place. The Madhya Pradesh High Court filed an order dated 22nd May 2026. Took notice of it concern, one of the concern of the family members of the deceased and directed that a second post-mortem examination was necessary to clear all doubts from any quarter and also to bolster the confidence of every common person in the entire process. We are informed that in reference to those directions, Sri Tushar Mehta, Learned Solicitor of India, representing the state of Madhya Pradesh, informs that in reference to those directions, the second autopsy was conducted by the All India Institute of Medical Sciences.
Lord, it was conducted at Bhopal. The team flew from Delhi.
Was conducted
By
by
the
a
team of
team
Delhi.
of doctors from the All India Institute of Medical Sciences,
Delhi.
New Delhi. Though the second post-mortem was conducted at Bhopal.
But other than bringing the body here,
That's
better
it.
that the doctors go.
That was the appropriate reports. Thereafter, the body has been cremated yesterday.
Yes.
And that report is awaited, my lord. The second report is awaited.
Next paragraph. The only issue as of now provides for consideration is the consent and recommendations made by the state of Madhya Pradesh seeking to hand over the investigation to Central Bureau of Investigation. Since the state government has already recommended investigation by CBI, our Learned Solicitor General has assured us that he will take up the matter with the authorities so as to ensure that the CBI immediately takes over the investigation and make an endeavor to complete the same promptly. We would like to impress upon the family members of the victim as well as the accused side that instead of making statements in public or before media platforms, they should get the person recorded before the investigating agency. So that no prejudice or adverse impact is caused on the ongoing investigation. As observed earlier, orally, we also request the media to avoid recording statements of the persons who are likely to be potential witnesses
Or accused.
as it may not unnecessarily give premature impressions and or as it may not unnecessarily prejudge the outcomes which are yet to outcome on certain issues which are yet to be investigated. We will also request the general public that they should refrain from speculation and ought to have trust and faith in the one of the premier investigating agency who, we are sure that in due course of time will take the investigation to a local conclusion. Next program. while making observations here and above, committee is clarified that we have not expressed any opinion on merits of the allegations or otherwise, and it is entirely to the investigating agency to look into the different aspects, scope versions, pros versions of the parties. Anything else at this?
That the high courts, etc., my lords, may be free to proceed. Since it's a suo moto, your lordships have constituted. High court, etc., can proceed in the manner if there is any petitions, etc., before the high court, my lords. In the manner, those courts. This may not come as if the other courts are denuded of that power, my lords, of the lower court or the high courts in the state of Madhya Pradesh.
But I have one thing.
Since your lordships are keeping it pending, since your lordships are keeping this pending, so it may not be that if we have to approach and exhaust our legal remedies by other courts, it's available to us, my lords.
For us to keep it pending. For us to keep it pending.
Then it's fine, my lord. Then it's not being paid.
But just one request, Lord. But I am not making that request today, but at some stage, Lord, if I leave the issue of my right to seek transfer open, Lord, because it should not be that we came here, we didn't make the prayer at the first stage. I'm not making it today, but I want that issue left open.
Transfer of what? Investigation.
We have not expressed any opinion with respect to the
Rights of the party.
rights or privileges of both sides.
Yes.
Which they might, for which they will be entitled to
Take a vote.
seek, which they will entitled to seek before an appropriate forum in accordance with law.
One suggestion subject to your lordship's approval. The lordships have said that those people who are likely to be potential witnesses may not give any media statements. If your lordships can add potential accused also.
Potential witnesses and accused. Yes, yes. Even they are also in a way defense witness.
Yes, but they might be accused themselves. So that's the.
Because tomorrow, whatever they unnecessarily will say, that might be their defense. So they should not unnecessarily go to media and make statements.
We're grateful, my lords, to your lord.
Grateful to your lord.
You are obliged.
Lord, the learned advocate general is also not online.
Yes, Mr. Prashant Singh, we have.
He has heard not everything. He was.
Lord, I am also assisting learned solicitor general.
Obliged to Lord.
We are
Grateful.
deeply obliged. Deeply obliged.
Thank you.
I appear for the Union of India in the matter. We have been served with the 500-page counter on Friday itself in 2.3. We may be granted 2 weeks for rejoinder, and it may be listed in the partial working days if my lordship deems fit.
All right, your directions are complied with. Land Council for Union of India stated that counter affidavit was received on Friday only. So 6 and granted 4 weeks time to file.
4 weeks time.
What's the matter also?
Grateful.
Please, my lords. My lords, here, my lords, we're pleased to issue notice. There is a response that has already been filed. My lords, this is a case where all the other accused, both in the EOW matter as well as in the ED matter, have been granted bail. For example, in EOW matter, my lords, there are in total 25 accused who were arrested, and 24 have been granted bail. I'm the only one who continues.
Just a minute, madam.
I'm sorry, ma'am. Yeah.
Item 9.
I beg your pardon, madam. Item 9. I'm sorry, my lords, I hadn't switched over. My apology.
Lord,
I didn't realize that.
So I appear in 9.
Yes.
The state.
My lords, I have a short note that I have drawn up, giving the details of both these matters, just to summarize it for my lords, the status. Would my lords just take this?
We have already
them also
granted bail to some of the.
I beg your pardon?
Some of the persons we have already granted bail.
My lords, everyone has been granted bail. My lords, may I just sum it up? In EOW matter, there are in all total 25 arrested accused.
No.
Out of 25, 24 have been granted. I'm the last one.
First item is that liquor.
EOW one.
EOW.
EOW. The state.
Predicate offense.
That's the predicate offense, my lords, arising out of the FIR.
No, this, we are just referring to the Niranjan Das 6457.
Please, my lord, 6457 is the EOW. It is arises in the predicate matter in which I'm seeking a bail. Yes, my lord. And my lords, in this,
This is the state FIR.
this is the state FIR.
That, as we call it popularly, that Chhattisgarh liquor scam.
Yes, my lords, it's called the Chhattisgarh liquor scam.
So we have granted bail to our.
My lords can see my lord's order at page number 221, annexure P18 in the case of Tawasi Lakshmi.
It's not a threat of tampering, there's no, that, yes, there's no threat of him tampering, at least. He's one of the most well-behaved.
My lords, I am a retired officer today.
Insofar as he is concerned, he was the main accused, main official.
They've said it for
who-
everyone.
All right, all are.
No, but I'm not.
It was
what I'm
said for
saying
all
is-
the accused, the same
My lord,
treatment.
He was the excise commissioner under whom this policy was tweaked, my lord. And then he gave the order to a company for, for holograms, my lord. And they're fake holograms, and which they used to, circulate fake liquor. Now, my lord, may kindly see, insofar as he is concerned, he was arrested in December by ED.
No, it is not your matter, it's the state matter.
The next matter is mine, my lord.
Well, next you are arguing in advance.
Because
let us.
So, he was only arrested in September, but investigation.
Right, the petition
His role was omnipresent. He was secretary excise, he was commissioner excise, and he was also the chairman of the marketing corporation. But
That is Arun.
that's Arun.
Yeah, that perhaps is not correct. I don't think my learned friends are aware. The chairman of the marketing corporation was Arunpati Tripathi. My lords have already granted it. I beg your-
Petition seeks enlargement on bail in FIR number 04/2024. Brought by the Economic Offence Wing of the Anti-Corruption Bureau State of Chhattisgarh. Lodged by the Economic Offence Wing of the State Police at ACB Police Station, Raipur, under Section 424, 468, 471, 123 IPC and Section 7 and 12 of the Prevention of Corruption Act. The petition was the Secretary, Excise Department, and it appears that subsequently he was appointed as Excise Commissioner after retirement. He was appointed after retirement as
serving, he was serving, he has secretary excise, commissioner
he
excise,
is said to have
and
commanded
managing director of Chhattisgarh
over the entire
Beverage Marketing
process
Corporation.
and was complicit in formulation of beneficial policy for perpetrating the alleged crime. Next, the petitioner was arrested on 18th September 2025. What is the investigation position?
Investigation, we are filing the final charge sheet. There's some last leg. We'll file the charge sheet within next 30 days.
We are informed that investigation is near conclusion and
For him, it's complete. For him, the predicate offense.
we are informed by landscape, by additional Advocate General that investigation for the petitioner is complete.
Yes.
And charge sheet is likely to be filed.
My lords, for him it is filed.
For him,
For him it is filed. They have filed in fact two charges thereafter too. Yes.
First, the investigation in respect to some other co-accused, some co-accused is still going on and is likely to be concluded. So, the trial, however, is yet to formally commence and its conclusion will take some time. The co-accused of the petitioner have already been released on bail by this court or by the High Court. The various orders, including order dated so and so, passed by this court in so and so. It's taken into consideration all the attending circumstances, or without expressing any opinion on merits, instant petition is allowed, and the petition directed to be released on bail, subject to furnishing bail bonds with satisfaction of so and so, impose the same condition as on the other side. Now, what is the next case?
My lords, the next is the ED matter.
EMLA matter.
I have given a note so far as that also is concerned, my lords. All the investigation is over. I was in the 5th prosecution complaint. They have subsequently filed yet another prosecution complaint. So investigation is still not complete. Yeah. Yes. My lords, they have filed a counter affidavit and page number 533. My lords will find this specific thing that they have said further investigation is pending in the ED case. Now, my lords, there are total of 6 prosecution complaints filed. I was taken in on the 5th prosecution complaint. They filed yet one, and according to them, it is still not over. Now, my lords, there were total 9 arrested accused so far. Out of the 9, 8 have already been granted bail. I'm the only one who's pending.
8 have been granted bail in PMLA also.
In the PMLA. I'm arguing just now the PMLA matter, my lords. And my lords, all the excise officers who were there, I was, according to them, the commissioner, but all the excise officers were granted bail without even arrests. Without even arrests, and they were granted anticipatory bails by this court. Now, my lords, even in this matter, there is no likelihood of any completion here because there are 81 accused, there are 117 witnesses, and there are 200 section 50 statements. So, my lords, and there are already 6 prosecution complaints, and yet they have not given the final complaint. So, there's no likelihood of this coming to a conclusion at any near distant future in this particular matter. There's not even charges which have proceeded here. And my lords, scheduled offense, as my lords have already seen, there are 1,200 witnesses in that scheduled offense and 55 accused. Now, ED can never conclude before the predicate offense is concluded in that. Now, my lords, I am respectfully praying they have filed a complaint against me. They don't need me at all.
But we have filed the PC in respect of this accused.
So your investigation is complete.
Not in respect of the whole offense.
Now your statutory complaint, how many years it will take?
Actually, it's a big syndicate which was operating.
Really press hard for early because it might unnecessarily lead to ignoring the vital evidence.
The POC, proceed of crime, my lord. I mean, so far as him is concerned, it's already over and we have filed the PC. But my lord, he was the main person under whose aegis the syndicate was functioning, my lord. And in fact, he used to give directions to the concerned officers not to.
That's why he will be the last one to go out.
He was the last to be arrested also, my lord.
My lords, he was always there. It was for them when they chose.
I
cannot have a role in that, my lords. It's not their case that I wasn't available.
So the petitioner seeks enlargement on bail
He was arrested on account
in a case registered by Directorate of Enforcement to ECIR stroke RPZ 04 stroke 2024 under sections. What is the provision at 3-4? Section
3-4 of the PMLA.
3 and 4 of the
PMLA.
PMLA. Pura लिख देना एक तरह. The predicate offence is FIR number 04 stroke 2024 dated 17th January 2024. वो जो पहले वाला बिल का प्रॉब्लम है, registered by the Anti-Corruption Bureau of the State Police by the Chhattisgarh State Police for offences and so and so. The petitioner was the Secretary Excise Department and subsequently he was posted as Excise Commissioner. He is led to have commanded oversight over the entire process and was complicit in formulation of beneficial policy for perpetrating the alleged crime. The role assigned to the petition is thus of the orchestrator, and he is described as one of the kingpins. It is also alleged that the petitioner grossly abused the public office, causing large-scale financial implications to the state exchequer. Next paragraph. The petitioner has been released on bail on the predicated offence by an order of given date passed separately. In the PMLA to the 19th December 2025. There are 9 accused. Also, 8 have already been released on bail in PMLA case also. So it is not in dispute that investigation is complete and statutory complaint has been filed.
Against the.
Huh?
This accused.
Against the petitioner. As a investigation for the petitioner is complete and a statutory complaint already stands filed against him. We find from the list of witnesses and the documents that are likely to be placed for consideration of the special judge that the conclusion of trial will take some reasonable long time. Keeping in view the being already spent in custody, when we call the fact that co-accused have already been released on bail, and that the conclusion of trial will take some time, or without expressing any opinion on the allegations from our direct the release of the petition on bail in the PMLA case also subject to the condition.
Conditions to be imposed by the consent court, Mullah?
Yeah, by this person.
I just wanted one.
Some conditions we have additionally imposed that will also apply here.
Please.
My lords, the one out of state, my lords have imposed on many other
That is
accused.
it.
I was only saying I'm a retired person. It's not their case that I have kind of interfered with anything so far.
No,
I
Mullah,
was
he is not
available.
operated, Mullah.
My lords, I have medical issues, I have heart issues. I leave it to my lords, but I would request my lords can
We will
consider that.
impose that condition because we want uniformity in conditions also. If we will make out a case of relaxation, then we will.
Please, Mullah.
Very well, my lords, we will.
Please.
Item 10.
We are grateful.
Is there any other matter also? Only 2.
My lords, there are 2 matters. Two.
Item 10 minutes, there is a counter by the other side. Sorry. This, according to me, will require some hearing. I was just requesting if your lordships will put it for hearing sometime in July or August, whatever date suits your lordships. I'll put in a short rejoinder. And my lordships on the last, my learned colleague, senior colleague on the last occasion were kind enough to say that till the matter is pending, the trial court will also adjourn the proceedings. Lordships will recollect this is the company. I am the liquidator of the company.
Lord, it will need a determination and it will take time. My Lord, there's no law covering either side right now. Of course, both are confident about their proposition being true. Put it, my Lord, in July on a non-miscellaneous day for final disposal.
Only thing is the trial, my learned colleague on the last time,
That-
lordships had orally said.
That is between you and me.
Yes, yes.
That's not for the court.
No, I was just, of course, Leonard was very gracious with us. August will probably.
So,
Why do we?
so
Next time they
as the matter requires.
Time will see.
On 21st post the matter. Any date available between 22nd or 23rd July?
July, I'll request.
July. Yeah.
My Lord.
There was one small thing I wanted to say. This is about how IBC code has to be interpreted when there is a fine for a company in liquidation. I was only wondering if IBBI can be implemented at my request so that that view will also be before your lordships. Whoever is right or wrong, I have no stake because I am the liquidator of the company. So the insolvency board can also have a say on what should be the correct interpretation.
I don't think we'll need them, my Lord. If my lords do,
Whatever your
we'll see.
lordships
I
say.
don't think we need.
Whatever your lordship.
Let us see.
Yeah, very well. Well, this is my only.
You both being their work perspective also you can highlight.
Yes, they will have another perspective also. Therefore, I thought, because otherwise we are all officers of the court, because we are the liquidator. Whatever your lordship says, I will do, Milas. I am the liquidator as far as that is concerned.
We'll see with the assistance of both of you can resolve.
Yes, Milas. Very well. Grateful to your lordship. Very, very grateful.
Please, Milos.
Is it MA Milos?
On 28th January, I was granted bail in both the matters, EOW and ED. Only in ED it came that I should not be staying. My problem is my son has a heart in the hole, and my wife alone is there to look after him. And it has come in the EOW. I have participated.
The report is of July 2025. Let me file a counter to their application, Milord.
Whatever,
They have to verify
I'm
the
saying is I be permitted to stay in EOW. Lordship did not impose that fine. While passing the order, it was at the end, Lordship confirmed the earlier order, so that condition came into. If Lordship says the order under EOW is on page 22. Page 22, no such, after hearing in detail, no such condition was imposed that I should be out of it. And he is now a 13-year-old boy, Millet, heart in the hole. It can be emergency any time. It doesn't get corrected. That's a physical incapacity which we have to live with.
This was never raised in the main bail application, Milord, this ground. And the report
The bail we
pertains
came in
to-
the upon the merits.
Report.
We didn't ask for on medical grounds.
Report.
When he gets the child admitted, we'll ask him to submit the medical report.
My lord, may kindly see, may allow us to just verify it because it's from a private medical.
How will you verify?
From the concerned nursing home or hospital, my lord.
Better your someone may accompany him when he goes him take him to the hospital.
Yes. My wife
That will
alone.
be the latest.
Let him.
That will be the latest report. Huh?
Yes.
May have it tomorrow, my lord. I'll just take instruction on that, my lord.
So, what the applicant is and an additional solicitor of India on behalf of the Directorate of Enforcement. Say, condition contained in para so and so of the order dated so and so is kept in abeyance. Is ordered to be kept in abeyance when the petitioner is permitted to visit his family for the treatment of his minor son, who is stated to be 8 years old and is suffering from a congenital cardiac condition. Requiring continuous specialist medical treatment in Raipur, Chhattisgarh.
Records are of July.
The petitioner shall take the child to the hospital within 1 week with advance intimation to the nodal officer of the Directorate of Enforcement at Raipur. The petitioner shall, after the child is examined by the hospital, after the latest examination of the child by the hospital, someone shall submit the necessary medical report, copy of the medical report to the Enforcement Directorate for their verification.
Very well.
In the event of any doubt on the genuineness of the report, the Directorate of Enforcement shall be at liberty to seek restoration of the
My lord, may not keep it in abeyance, my lord. His entry, he may notify us. Entry to Raipur or Chhattisgarh may be notified to us. He may go and may not keep it in abeyance, my lord. If, for example, may have it after vacation, my lord. If, for example, he is required to be there for further treatment or
It's not that Eric's her surgery. This is a condition anytime the child can have, and my wife is alone to look after these child.
medical report, which, because it's serious doubt, my lord.
See, if the child is 8 years old, child requires this kind of treatment, then As a father, he has to.
He may not keep it in abeyance. May direct that he will report to us.
Abeyance means that we are not recalled. The condition is there, but condition is kept in abeyance.
Say, to inform about his entry in Raipur, Virat.
So that's why we are saying that you can always apply if you have any doubt about the medics. No.
Deeply obliged, please.
May I, Lord?
Lord is keeping it pending, Virat is saying?
No, this point.
The issue of solicium and interest.
Obliged.
Milord, the issue of solicium and interest has already been decided by this court, Milord, in Tarsem Singh, Milord, matter. And Milord.
Instead of filing contempt, where is your matter now pending?
Milord, 34 petition is pending, Arbitration and Conciliation Act, section. Before District Judge Mathura, Milord.
So District Mathura, you request District Mathura to decide it.
Milord, I have given representation. Despite representation, they are not deciding, Milord. In review petition, your Lordship.
34 is pending.
District Mathura, madam.
Lordship in 2013.
Claim for enhancement would be decided. Then he will also grant you solicium and interest.
Milord, it will take much time, Milord. 2013 land is acquired, Milord. And your Lordship has directed a review petition when the NHAI has filed. All landowners whose claims the quantum and or component compensation for the land acquired under the NH Act were alive or after 28/3/2008. They were pending before one of prescribed fora shall be entitled to seek addition of interest, solicium and interest of the solicium to their compensation claims.
So where they will seek? Where will they seek that interest and solicium?
Milord,
where the proceeding is
under section 34.
You take out an
Milord, it will take time, Milord. I will only request, Milord, may direct them to consider my representation.
Decide in piecemeal because you have rightly approached the district judge for enhancement. 34 is the right way.
Yes, Milord.
So we can only direct the district judge to expedite and decide, and while deciding, he will also determine the amount of solicium and interest you are entitled to.
Milord,
the land of the petitioner and his family was acquired by National Highway Authority. The petitioner's land, as a petition land in Moza Semri, Tehsil Chhatta district, Mathura, was acquired by National Highway Authority for 6 lane of Delhi-Agra National Highway. The acquisition took place in December 2009 and February 2011. Award was passed by the competent authority on 7th June 2013 without solicium or interest. The aggrieved petitioner has filed Section 34, a petition Section 34 of the Arbitration Act as per Section 3 capital G in bracket 5 of the NH Act, which is pending before the arbitrator cum District Judge Mathura. That is a petition for enhancement of the compensation. Next paragraph. The petitioner has filed the instant contempt petition, inter alia alleging that non-payment of solicium and interest on the original compensation amount is a willful and deliberate breach of the directions issued by this court in Tarsem Singh 1 and Tarsem Singh 2. So and so, so and so. Next paragraph. In our consideration, the appropriate recourse for the petitioner would be to pursue his petition pending before arbitrator cum district judge for further enhancement of compensation. It goes without saying that the learned arbitrator from district judge shall also determine the petitioner's claim for solicium and interest in accordance with the decisions of this court relied upon by the petitioner. So, keeping in view the fact that the land was acquired way back in 2009-11, comma, we direct the learned arbitrator come district judge Mathura to decide the petitioner's claim expeditiously and preferably within 6 months.
Grateful.
My lordships, the question of law and issues in the present petition are already sub judice before this court in the SLP civil number 7649.
Where is the subvention clause?
My lordship, however, there is no clear subvention laws, but it is to be noted that the primary liability was of the builder to give out the possession. And as per RBI circular dated 1st May 2015, the bank had the duty to make the payments stage-wise after due inspection of the construction ongoing. However, the tripartite agreement in this matter was signed on 28/8/2020, and the payment of 42 lakhs, which is almost 90% of the sanctioned amount of the loan, was dispersed to the builder on within 5 days. That was on 25th August 2020. So therefore, we are not asking here to waiver of the loan, but we are only asking that the present matter be tagged with the already ongoing batch matters and interim protection be granted to us against the coercive recovery proceedings before DRT 1 Delhi.
What happened in NCLT?
The builders have been already declared insolvent by the order dated 15th April 2024.
Okay. Subvention clause to me. Then subsequent. Returnable. What is the date in the other matters?
27th of May.
Issue notice returnable on so and so date, tag with so and so. Meanwhile, no coercive action shall be taken against the petition. Very good, keep it up. Well prepared. That order of attachment can't be passed in your case because already there is a CIRP.
My lord, I am appearing for the petitioner here. My lord, the children of 10-year, 11-year, 12-year, they are made, they are used in the orchestra, in the dance bars. And my lord, as far as the spa and massage parlors are concerned, some of the states have made the rules that it should be 18-year plus. At page 139, annexure P12, I have a next. My lord, in Delhi, in Tamil Nadu, and in please.
Mr. Fulka, it's a very serious issue. We would like to issue notice. We would like to.
Yes, my lord. So grateful, my lord.
Issue notice.
For item number 50, I'm seeking a short passover. For item number 50, I'm seeking a short passover.
It's a short issue just for appointment of an arbitrator.
I'm led by my
Substitute arbitration.
Just for appointment of a substitute arbitrator.
He's appearing for respondent. If he's
I appear for the petitioner.
You are appearing for the petitioner. Who is appearing for the respondent?
the arguing counsel is in another court. So
No. Are you assisting the same?
No, it's for the petitioner. I'm for the respondent.
You are for the respondent. Don't get stressed. Be relaxed. There's nothing we are doing that. The only request is, as Justice Bopanna says, that I may be recused because he does not want to do arbitration. So why don't you suggest some other name?
Anyone from Karnataka High Court?
Justice Ravindran, my lord, because the arbitration clause mandates an appointment of a retired judge of the Supreme Court of India. So we informally sought his consent. He's agreed. Justice Ravindran is based in Bangalore as well.
Any issue?
No issue.
We hope that Justice Ravindran's health is fit and fine.
Yes, my lord, he's hale and hearty.
Very good, very good. So, Justice Ravindran. That's all.
My lord, I am item 16 and withdrawing.
Completely frivolous petition,
I'm
my lord.
withdrawing
It's
this matter.
coming up on 28th, my lord, for 29th for hearing, my lord. And he
Yes,
is
I'm
preempting
withdrawing this matter.
something. He is filing a PIL challenging the appointment of the Secretary of Ministry of Ayush because he has done cleansing in the department, my lord. Now he is pursuing there and then he has filed this SLP when the matter is fixed for hearing on 29th itself, my lord.
I am withdrawing this matter. Yes. I'm withdrawing this matter.
Withdrawing.
So,
Hello.
Grateful. I'm an advance notice, my lord.
Yes.
Physical appearance.
Mark for the additions will be. As per central, additions will see what we. Item 17.
Yes. My lord, this was the case of a tender. And I have come against an ad interim order, but my lord, the facts are shocking. I want to lordship just my lord note two facts. This is the toll collection case, my lord. There is a tender, my lord. In the tender, my lord, I am the highest bidder. If your lordship will note, my lord, on a per day collection, something important.
But there is a huge gap, Mr.
I know, my lord, I'm coming to it. If it was the case of huge gap, my lord, your lordship may dismiss my case right now. My lord is seeing the gap because what I bid was 2 crore 32 and this is now 5 crore. Lord. That's the gap. The actual reason is this, not this, my lord. The actual reason is I was the highest bidder at my lord 222 or whatever. On the same day, I'll tell you the reason. I will tell you, my lord, the Chief Justice's question is the most important question. Why this double gap? My lord, Chief Justice's question is, why the double gap? My lord, on the same day, when the highest bidder is at, my lord, 226 crores, on the same day, you cancel it and put a reserve of 555 crores, which is double. There has to be something shocking. What has happened on that day and this day? The reason is this.
No, nothing is shocking. They don't want a tender to come because the existing one is continuing.
Simple. That is the ground I raised, my lord. He is at 47 lakhs a day. I am at 62 lakhs. So 47 lakhs was allowed 3 months in November 24. We are, my lord, in middle of 26. And I have said it very clearly, as Justice Bagchi pointed out, my lord, this is what is going on. The High Court doesn't see through it.
But the only thing is, suppose now that the tender has been issued.
Right.
If
I'm saying one more thing.
Nothing to this is absolutely incorrect what is being said. It's the matter on 8th June now.
That doesn't matter if it's on 8th June.
Vacation bench has said that look, we are making it subject to further
Subject means
orders.
what, Lord?
All
This is
participants,
absolutely
we can
gross.
participate. All participants are to do it.
Not at
File
all.
your reply. We have filed our reply so that there is
Would you
no
not
delay.
just
Now it's
allow
kept
me?
on the 8th of June.
This is, my lord, this is a gross.
And there are very
It's a
strong
gross
reasons why.
scheme which is going on. Turn to page 3 for one second.
the point is, Mr. Rodgi, now that tender has been floated.
Yes.
If someone comes with an offer of say 530, 550, whatever it is.
No problem.
Minimum.
Give it. But if, my lord, they scrap this tender because nobody will come at 550, I know. Then your lordship will record that that fellow must stop. He can't go on. He can't go on like this. Now this fellow, my lord, now.
You propose to modify this injunction.
Yes.
What they permitted is without prejudice to your rights, he will participate.
Yes. Yeah.
Let the tender be subject to the writ petition.
Your lordship must do that. And also, if this tender is scrapped for some reason, then the ad hoc chap,
Yes,
my lord,
yes,
who's
everything
continuing
will be
at a
subject to
much
this writ.
lower rate, he has to stop.
It's already provided for. Your Lordship, may clarify that. Please just see
Because the High Court has not seen through the game.
There's no game.
This
Just
is the
see,
game, absolute game.
in our
There is no
considered
game.
view, the interest of justice would be met by
There is no interest
subjecting
of
the
justice,
fresh.
Lord, which is going on.
Please see the last line on page 6.
And this, my lord, this man has quoted 186. My bid was 222, increased to 232 in negotiation, then cancelled. He is at 186, and now the demand is 550. I am saying if they're not going to get 550.
Itself is subject to the writ petition.
Yes,
I'm saying
please
something else.
expressly made.
1 minute, please. I'm saying something else. If they've cancelled this contract, my lord, for not getting 550, the first thing they must do is to, my lord, remove that interim guy who's continuing Milord for 1.5 years at a much lower rate, appoint somebody else as an interim person.
If they do not get a bidder.
Yes.
Up to 550.
Yes.
Your case, in fact, is established before
I agree.
court.
But Milord, they are all mixed up.
Entitled.
They are not going to go by this law. They will say, sorry, your tender is out. Forget it. Now we are on a new wicket. New wicket, somebody comes, doesn't come, we will not continue that chap. This is what their game is.
They have to demonstrate some cogent, compelling reasons for cancelling the previous bid. No doubt, a concluded contract had not taken place.
Correct.
But within 1 month, going with a higher...
on the same day, Milord, after negotiating with me, you
permitted them to negotiate with you to increase your bid.
I did.
And you were participating.
Milord, I was called for negotiation. I increased it, Milord. The law is, this is something, Milord, just a game which these officers are playing.
Bids.
29th
of...
they are asking me to bid without prejudice.
Yes.
They are asking on 29th. The reason given for cancellation of my contract is administrative. What is this administrative, Milord? Only, Milord, to continue that fellow.
We have filed
I am
reply.
saying, Milord, please. I am saying 8th June, Milord, is not far away. 8th June is not far away. Milord, prior to decision of the court, they should not finalize. Another third party will now come in. So let them look at it on 8th of June today, Milord. When the game is this, to allow that man to continue.
This Maharashtra State Road Corporation.
Yes, I'm for R1 and R2.
So you have to finalize the new tender.
I have to?
You will finalize the new tender.
Yes. Yes.
29th is the last date.
Yes. For receiving bids.
How soon will you be able to decide?
I've not taken instructions on that, but it's bound to take some time. It's bound to take some time.
How much time? Because
I will make a statement that I will not make any award before the 8th of June, which is the next date of hearing. But it is not to be construed as a stay. I'll make it very clear, because I'll tell you what's happened. We have filed a counter affidavit in the High Court. What had happened here was that there was a study which was conducted. That study showed a huge surge insofar as traffic is concerned on that thing. So therefore, on the basis of that traffic study, the authority found that because there was such a huge increase in traffic between November, I think the study is between November and March, April 2026, there was a need for going through with a new tender because the reserve price had to be increased. So there was a massive loss. So there was a whole foundation for this. We have placed this on affidavit. Because now I am suggesting,
completely wrong, Milord.
see, if you are earning a little more exchequer, we have no difficulty with that.
That's what has happened. That's what the estimate is.
The concern is that ultimately, suppose you don't get anything, and a person who
Milords, I am saying it will be subject entirely to the orders which are final orders which are passed in the writ petition. The writ petition is coming up on the 8th of June. When the court considered in paragraph 19 of the impugned judgment that, look, should we change the dates? They realized that this is a pivotal infrastructure project for Mumbai. Since it's a pivotal infrastructure, the correct and appropriate order, which I am also commending to your lordships, is that, look, all further action will be subject to final orders passed in the writ petition. So they will examine our reply. If they are satisfied, there is no question. My learned friend is making allegations about some third party. He has not even implemented that third party in the writ petition. I just saw the court title. So where's the question of malafides, etc.? So you just make an oral submission as you like without even implementing the party. It's not even, he's not implemented him as a party respondent. And that person, let me tell you, is not conducting because your lordship's apprehension was that is there some tender being automatically extended. That is a separate issue. That's a commission basis. So MSEDCL is drawing the money. He's only getting he's only receiving a certain fixed commission.
47
and in
lakhs.
any case, we want to complete this the earliest, and we want to make a quick award as far as this particular tender is concerned. So, Manoj, please don't interdict. The matter is coming up on 8th June.
I can show you this study argument is completely bogus. As per their study, the figure is 62 lakhs per day and I have offered 63 lakhs. What are you talking about this study? Administrative reason. Then you would have said, this study, my lord, was prior to the issue of this tender. From 62 lakhs per day, I increased to 63.5 lakhs per day. And that fellow is continuing at 47 lakhs. This is the way, my lord.
Different study. There were
It's
two
absolutely,
studies.
my lord.
Anyway, that we'll place on reply, etc. But I would
They will finalize
please
without
don't
the leave of
expedite this entire process. Let it go through subject to orders. Subject to final orders. And we can make a request to the High Court to take it up on the 8th immediately.
The Supreme Court will make it an
For
order.
the instant special
Will be taken up.
petition directed against. And Surya Motu 15th May 2026. Passed by the vacation bench of the Bombay High Court. In terms whereof
January to May to May,
interim stay on the tender cancellation horizontal dated 29th April 2026 has been declined. So, by safeguarding the interest of the petitioner, with the two conditions that the petitioner may participate in the press tender process without prejudice to its rights, and that the press tender floated by the first and second respondents on 29th April 2026 shall be subject to outcome of the repetition. The matter is now pushed before the High, next paragraph. The matter is now listed before the High Court on 9th June 8th June 2026. Next paragraph. We have heard Pancholi the counsel on behalf of the petitioner and the Diwan and counsel for the counsel on behalf of the Maharashtra State Road Development Corporation. We are informed that the last date to submit the press tender is 29th May 2026. So, having regard to all the attending circumstances, we direct the Maharashtra State Road Development Corporation to finalize the press tender subject to the conditions imposed by the High Court, before 8th June, by 8th June 2026, and submit a report on the sealed cover before the High Court.
Very well.
Very well.
The follow-up action will depend upon the outcome of those proceedings.
Grateful.
Grateful. Sealed cover.
Because after the first FIR was closed in October, 12 FIRs across 4 states, Malats. I'm really running from pillar to post. Malats, if your lordships are not inclined, can I withdraw to seek other appropriate?
Our view,
We are not inclined in these sort of cases to club the FIR.
Well, your lordships will permit me to withdraw to seek other appropriate remedies.
Yes.
Very well. Very well.
Full कर दिया.
What voice is good?
Lord, this petition seeks regular bail. But Lord, have a look at my chart. This is a case of evergreening. Whenever I am in, out, I've got bail everywhere. So Lord, now 2.5 years have gone by.
Scam altogether. This is a different scam altogether.
Oh, wow.
And
Sir, but when was the trap? When was the trap? November 23?
Absolutely.
When was the FIR?
24.
October 24. Why? A person, you are right. This is with regard to a different aspect of the liquor scam.
Absolutely.
You are absolutely right. This is with regard to human resource.
Yes, please.
There, the liquor itself was being manipulated, money was being made. Human resource is being manipulated.
So this is a manpower
arrest from Eagle Hunter is on November 23.
Yes, please.
Till ED tells you you don't lodge an FIR.
This was not in the.
It's not that at that time these people had the control over the state administration.
The issue.
Lord, 7 charge sheets have been filed in the liquor scam. Now you take out another FIR.
Back then, in October 2023, the accused here had a political patronage.
What political?
He was.
He had no political patronage.
The state, ED had, but the state was informed and the state chose not to register the FIR. It's only when ED wrote subsequently again.
The state was not aligned with the principal conspirators as you allege in 2023. We would have completely agreed with you if the political executive of the state had been replaced in the meantime.
Yes, Minister, it has been.
No, not in 23, earlier, in 21.
No, Minister, the political regime changed in December 23. And that's why, because...
So, even if you say December 23, see, October 24 is the registration of...
FIR, yes, please.
What is this?
So after,
every 6 months there's an FIR. Every 6 months I have to take. We'll just have a look at it.
Only this scam alerts
kindly just pass it on.
Been perpetrated in Chhattisgarh. Same modus operandi was also no, not UP alerts. Here in Jharkhand, my lords, give us 1 week time, we'll file a.
Just have a look at this.
Same.
Just see this.
May at least give us time to file a counter
alert. See this. Now the liquor scam, ECIR of ED is of 22, date of arrest 23, FIR liquor EOW, date of arrest April 24, FIR liquor UP, date of arrest 18 June, same facts. ECIR for liquor ED for UP, 8th of August, FIR rice EOW, 9th of July, every 6 months I got bail.
We are issuing notice.
I'm pleading for interim bail. This is not subject to any condition.
Give us 1 week's time, we'll file a counter.
One second, please. This is the gross violation of Article 21, my lord, to do this again and again and again. My lord, give me interim bail, keep it after 2 weeks.
We'll ask them to file reply by Friday.
Yes, we'll
file on 1st June, Monday.
All right. Let's do that.
File the reply by.
I would prefer if my lord the Chief Justice takes it on Friday.
Can it be?
Give it, not they will reply by day after.
Can it be on 3rd? First. I am in personal difficulty.
Ceremonial benches and.
I would submit that it should be before your lordship.
Third.
Chief first doing that.
Well, your lordships are sitting in the first week because the other matter of mine also your lordships were pleased to put on the first week.
No, there will be bench available. We may not. Bench also notified already.
Benches are not notified.
No, notified.
Not notified.
Not yet.
Mr. Passing, is it not notified?
Benches have not been notified.
Benches have not been notified.
Benches are not notified.
From my side, I have clear.
It has not, circular has not come.
Circular.
So some judges have told me in court that they are sitting in the first week. That may not,
yes,
that way, but not.
I also know, but otherwise.
Benches are available throughout the past working days. Sufficient benches are there.
Very good.
So if I reply issue one, two item 32 and 32.1.
32.1, there is a.
First, I'm in personal difficulty, Millards. My mother may get operated on first.
First,
Second,
Third, my lords, if my lords may keep it on third.
polite on third. On third.
Much same bench.
In 32.1, Lord, there is it should not have been actually tagged. It is the same FIR, but here grounds of arrest were not given, admittedly not given. Orally informed, grounds of arrest, signature taken.
Item 32.1.
32.1. If your lordship have not read that, Lord Lordship have it tomorrow. Otherwise, Lord, this is a
We'll file a
separate case.
counter, Millards, on the same day.
No, grounds of arrest is not given, Lord, your lordship. Several, not one, but two judgments of this court. Lord, now your lordship says 2 hours before the remand is filed, you have grounds of arrest has to be given. Justice Vikramnath also in a recent judgment.
it has been produced within 30 minutes.
No, 1.5 hours. But no ground of arrest.
Say that is in breach.
But Lord, the
2 hours when the detention prior to production is more than 2 hours.
2 hours.
Thing, consider this case. Will you press on grounds of arrest or will you ask for bail on merits?
No, I'll consider both, but I'll tell your lordship.
So if you consider both, it would be better for you to withdraw this and file a bail application before the High
Can
Court.
I say this, Lord? I'll be able to say
Consider
on this. That this is a case where, admittedly, let me assume grounds of arrest 2 hours because of your lordship is like 1.5 hours. But grounds of arrest in any case should be given to me. That is not given to me. Admittedly not given to me. It was served finally to me along with the charge sheet on 18th of May after the filing of this petition also.
We'll verify, Millards, and
file counter.
We'll file counter, Millards. We keep this matter on third.
That would your lordships keep it this side of the vacation because
Practically not possible because 28th is holiday. 29th again ceremonials and
then let it be. Then he'll take only third only. Then.
on 3rd June we are keeping.
Then along with the other matter.
Yes, both matters.
But let it not be tagged, Lord, because then your lordship.
No, this should not be tagged. It will separate.
It's actually separate.
Point is completely different. We don't know why.
Deeply obliged.
So the listing.
Today also in another court, Lord. Actually, today in another court also. No,
Yes,
Lord,
yes,
that's
same
not
affair.
the issue.
That is right.
Somebody should analyze. In another court, Lord, there was a criminal matter and a civil matter. Some parties were common. Tagged. The judges have not read the other my file. So that's a serious problem. Somebody responsible should see.
Matter where it was brought to my notice that a criminal matter has been tagged with civil matter. But then I immediately try to find out. There was a statement made by some young counsel that this matter should be taken up along with those.
No, not in my matter, Lord. Not the matter which I have been because of which, Lord, the learned judges have not read the file, so it is kept separately. That becomes a problem. Deeply obliged, Lord. Third, then.
Separately.
Your matter, we had read the file.
Very well. That I could take on, Lord, from your lordship's comment. Deeply obliged.
Item 33.
May I please, Lordship? Lordship, this Honorable Court order dated 27/4/2022 constituted the committee, Lordship, identified the beneficiaries throughout the nation. But the past 4 years that is in committee is not.
Modifying.
Entertain this kind of.
Lordship, that is in past 4 years that is in completed, Lordship. Some time limit, Lordship. That is.
Millards, 34, I beg to appear, Millards. This has to be tagged with the other matter.
Other party is.
But Millards, the interesting case is my JV goes up in appeal first. Appeal gets allowed on identical facts.
See the cross case.
Yes.
Issue notice tag to be taken up along with CAD number 15918/2020.
Great, Millards.
Yes, Mr. Sahi.
Lordship, the contempt petition is brought in the light of order passed by the Honorable Apex Court of India dated 18/11/2024. So, Lordships, the it goes without saying that the appropriate forum shall consider such a claim in accordance with law and shall not be influenced by the impune orders of the High Court merely because the petitioner chooses to adopt an erroneous recourse for determination of his right to compensation ordered accordingly. Lordship, the arbitrator has assumed that no order has been passed by the Honorable Apex Court of India. The order passed by the arbitrator can be compared with the order passed by the Honorable
Said, Mr. Said,
Lordship.
earlier we dismissed your petition saying that it was not maintainable.
Lord.
But at the same time, we allowed you to approach the prescribed authority, right?
Lordship.
After that, you have approached that commissioner who is the statutorily prescribed arbitrator under the Act.
Lordship.
Your claim for determination of compensation is pending before that authority.
No, Lordship. The matter has been disposed without giving notice to the respondent.
Then challenge that order, please. Challenge that order. What is the contempt? You are a lawyer.
But Lordship, there is the question that they have defied order of the Honorable Apex Court of India. Order Supreme Court का कुछ उन्होंने लिखा क्या है? The division bench was of the view क्या है? Supreme Court के order के साथ they have played.
Sir, what happened to your matter in the before this commissioner?
Lordship.
What happened in that matter which you filed before the commissioner as an arbitrator?
The commissioner has finalized the matter, Your Lordship. The commissioner has finalized the matter.
Finalized the matter. So some award has been passed.
Award has been passed.
Award might be against you. Award may be in your favor. Award may be partly in favor, partly against. Challenge that award.
Lordship, so Lordship, question is this: I approached the Honorable Patna High Court under Article 226. The petition was dismissed. I approached under Article 32 in the Honorable Apex Court of India, claiming that my fundamental rights have been infringed under Article 14, 21, 31 proviso. That was dismissed, and I was given some words of the Honorable Supreme Court, like the purse and diamonds for myself, and now all have gone in vain.
Please understand. Please understand. You are an advocate. It's your personal matter. When you argue unnecessarily, you sometimes get confused.
My lord, I am carrying my pyre. आखिरी ब्लड खत्म हो चुका है.
And by us, tell us, what can we do now?
लॉर्डशिप उनको बुलाया जाए, पूछा उन्होंने ऐसा किया क्यों?
क्या बुलाकर क्या पूछे उनसे बताइए?
लॉर्डशिप उन्होंने सुप्रीम कोर्ट ऑर्डर साथ ही खिलवाड़ किया.
सुप्रीम कोर्ट ऑर्डर अगर उसने आर्बिट्रेटर ने कोई अवार्ड पास कर दिया है, मान लीजिए आपका क्लेम उसने रिजेक्ट कर दिया,
बस
क्या आपने बता नहीं रखा इसमें? हम अंदाजे से पूछ रहे हैं. उसने क्लेम आपका रिजेक्ट कर दिया, तो उसको चैलेंज करो आप.
लॉर्डशिप हम कहाँ जा सकते हैं?
अरे भाई, आप एडवोकेट हैं, आपको तो आपको क्या प्रॉब्लम है?
एक बार उनको बुला के
तो बेचारा गरीब जमींदार को तो, गरीब किसान को तो है, आपको क्या प्रॉब्लम है?
लॉर्डशिप हमें मिला क्या? आखिर यही तो मिला था जरा सा, और इसके साथ भी लॉर्डशिप
कहीं कोर्ट में जाएंगे, चैलेंज करेंगे तो आपको कोई आपके कानून के आपको जो आपको बनता है मिल जाएगा आपको.
लॉर्डशिप हम तो मर जाएंगे, हमारी आने वाली पीढ़ी भी मर जाएगी, इसमें पैसा कहाँ है? लॉर्डशिप ये सोचा सकता है लॉर्डशिप कि आर्बिट्रेशन एक प्रक्रिया नहीं है, आर्बिट्रेशन एक डिसीजन है.
तो आपके
लॉर्डशिप
सारे केस जीतते होंगे, आप इतनी भावुक होकर के बहस करते हो तो
नहीं
कोर्ट भी बड़ा कंपैशन में आ जाता होगा.
नहीं सच है लॉर्डशिप,
नहीं होता होगा.
बस लॉर्डशिप अपनी अर्थी को ढो रहे हैं, माफ किया जाए. उनको बुला के पूछा जाए कि उन्होंने ऐसा क्यों किया, देखा जाए कि उन्होंने ऑर्डर में क्या लिख दिया. ऑर्डर यह है, उन्होंने लिख दिया कि द डिवीजन बेंच ऑफ द व्यू. अब लॉर्डशिप
वो ये बोलेगा आकर के हमें कि जी मेरे अंदर तो जितनी बुद्धि थी, जितना मुझे आता था कानून, मैंने तो उसके हिसाब से ऑर्डर पास कर दिया. अगर इनको मेरे ऑर्डर से कोई समस्या है तो बड़ी कोर्ट में चले जाएं. क्या जवाब देंगे हम उसको?
लॉर्डशिप जनरल कोर्ट वहां हम जाते तो नहीं था.
उसको बोलेंगे आपने साहिब साहब को नाराज किया है, इसलिए हम कंटेम्प्ट में अंदर कर दें आप.
लॉर्डशिप हम सुप्रीम कोर्ट आए हैं, और ऐसा कोई आर्बिट्रेशन होता है लॉर्डशिप कि उन्होंने रिस्पोंडेंट को नोटिस तक नहीं किया, और आर्बिट्रेटर इज नॉट लेस देन IAS ऑफिसर. लाल बहादुर शास्त्री अकेडमी में उनकी शिक्षा हुई है. लॉर्डशिप हम इंग्लिश बोल सकते हैं, माफी चाहते हैं, लेकिन चूंकि हम काफी घबराए हुए हैं इस उच्च वातावरण से. और
इस वातावरण से आप घबराएंगे? वातावरण तो आपका रोज का देखा हुआ वातावरण
नहीं. हम
क्यों घबराएंगे आप?
लॉर्डशिप पे थोड़ा सा पढ़े हैं, लेकिन इतनी ऊंची बुद्धि में
बात सुनिए. आप कितने साल से प्रैक्टिस करते हैं?
लॉर्डशिप प्रैक्टिस तो कर रहे हैं 2004 से, लेकिन सच है लॉर्डशिप की इस प्रोफेसर 2004 से
2004 से आप प्रैक्टिस कर रहे हैं साहब
जी.
तो आपको पूरे 22 साल प्रैक्टिस करते हो गए
जी.
आप किस बात के लिए घबराएंगे?
थोड़ा सा घबराहट होती है। हमने सच बयान किया है, झूठ नहीं कहा है। लॉर्डशिप, सच ये है कि सुप्रीम कोर्ट के ऑर्डर का उन्होंने खिलवाड़ किया है, तो हाउ डेयर ही डिड सो, इसलिए उनको बुला के पूछा जाए, हमारा कल्याण हो जाएगा।
साहब अंडर वो आपका जो है ये नेशनल हाईवे एक्ट है, उस एक्ट में वो एक स्टैट्यूटरी प्रिस्क्राइब्ड अथॉरिटी, राइट
लॉर्डशिप,
वो एक स्टैट्यूटरी अथॉरिटी है जिसको एक्ट में ये पावर है, उसके पास ये शक्ति है, उसको ये संज्ञान लेने का वो है, उसके पास ये अख्तियार है कि वो आपका डिटरमिन करेगा कि आपको कितना कंपनसेशन मिलना चाहिए। हो सकता है आपके हिसाब से सिंबॉलिकली बता रहे हैं, मान लीजिए आपको लगता है कि आपको 1 लाख रुपया मिलना चाहिए, हो सकता है वो आपको 50,000 रुपये दे, आपका एग्रीमेंट जायज हो सकता है, लेकिन वो जो कानून में जो प्रक्रिया है उसी के हिसाब से करोगे ना।
लॉर्डशिप, यही तो हम भी कर रहे हैं कि पैसे का सवाल नहीं था। लॉर्डशिप एक बात, पैसे का सवाल नहीं था, सवाल यह था कि उन्होंने
पैसे का सवाल
नहीं किया।
क्या सवाल है फिर? आपकी उसने भावनाओं को थोड़ा सा वो कर दिया।
लॉर्डशिप सवाल यह है कि उन्होंने आर्बिट्रेशन प्रोसेस को पूरा ही नहीं किया। इसका सेक्शन 21 देख लिया जाए, आर्बिट्रेशन कॉन्स्टिट्यूशन एक्ट कहता है कि बिना रिस्पोंडेंट को नोटिस किए यह हो ही नहीं सकता है। नहीं इस पर एग्रीमेंट हुआ, नहीं किसी का आर्गुमेंट हुआ, बैठ के टेबल पर बैठ के उन्होंने ऑर्डर पास कर दिया।
उस एक्ट में नेक्स्ट अथॉरिटी कौन है? एक्ट में नेक्स्ट अथॉरिटी कौन है?
नेक्स्ट तो फिर अब जो है जिला जज है, इनके खिलाफ जाना पड़ेगा पंचायत के पास।
डिस्ट्रिक्ट जज होंगे मेरे ख्याल से।
जी हाँ, डिस्ट्रिक्ट जज है
वो 34 का, क्योंकि ये है ओरिजिनल डिटर्मिनेशन। कमिश्नर जो करता है वो पावर है तकरीबन सेम पावर जो लैंड एक्विजिशन कलेक्टर की
जी।
उसके बाद 34 की पावर है वो है डिस्ट्रिक्ट जज के पास। तो वहां जाइए, डिस्ट्रिक्ट जज के क्लेम डालिए, हम डिस्ट्रिक्ट जज से रिक्वेस्ट करेंगे, उसको थोड़ा सा आदेश भी देंगे कि आपके क्लेम को जल्दी डिसाइड करें।
लॉर्डशिप यही आदेश कर दिया जाए, जो दे दिया जाए, हम क्या कर सकते हैं। लेकिन लॉर्डशिप क्या रखा जाए? आखिरी बूंद
का केस नहीं बनता आपका, शाही साहब।
लॉर्डशिप आखिरी बूंद खत्म हो चुका है, जिला नवादा हमारा है, आखिरी बूंद खत्म हो चुका है, अब मर रहे हैं हम। आई एम फेसिंग स्टारवेशन। 3 कट्ठा जमीन गई है लॉर्डशिप, जो कि एकदम सड़क पर की जमीन गई है।
और सरकार डेट है जिस दिन कमिश्नर ने ऑर्डर किया, उसकी डेट क्या है?
जी, उसका डेट है 23 फरवरी 26। 23 फरवरी 26 है।
इसको चैलेंज नहीं किया
जी?
इस ऑर्डर को चैलेंज नहीं किया आपने अभी तक?
जी नहीं, चैलेंज तो नहीं किया लॉर्डशिप।
क्या करते हो शाही साहब आप? दोनों या दुनिया को आप कानूनी सलाह देते हो और आप अपने मुकदमे का ध्यान नहीं रखते।
लॉर्डशिप, हमें भरोसा था ऑनवर्ड सुप्रीम कोर्ट
23 फरवरी का ऑर्डर हुआ है, आज मई खत्म होने को आ गया, आपने लिमिटेशन का ध्यान दिया कि नहीं दिया?
यहाँ लिमिटेशन 90 दिन का था, लेकिन हमने तो 10 अप्रैल को ही फाइल कर दिया था यहाँ ना पिटीशन।
आप जाइए इसके खिलाफ चैलेंज कीजिए। से we have heard the petition in person. The instant contempt petition has been filed on the premise that the commissioner cum arbitrator under the National Highway Act on the premise that the divisional commissioner cum arbitrator from a Magad division, Gaya ji, Bihar, has not followed the directions of this court while passing an award on 23rd February 2026. It appears that the land of the petitioner, comprising Khata number 77 in village Repura, Revenue Circle, Maskur, Nevada, Bihar, was acquired for construction of NH 84.4. The compensation amount was determined, against which the petitioner filed a petition that the petition was disposed of with the direction that the petitioner grievance be considered by the commissioner cum arbitrator under section 3 capital G in bracket 5 of the National Highway Act. Instead of availing that remedy, the petitioner firstly filed an intra-court appeal and thereafter a writ petition before this court. The said writ petition was dismissed being not maintainable. So the petitioner was granted liberty to approach the prescribed authority for award of just and fair compensation. Thereafter, the petitioner approached the divisional commissioner, cum arbitrator, Mother Division Gayaji, and as noticed at the outset, his claim has been, his claim for enhancement has been turned down by the said authority while an award dated 23rd February 2026. Next paragraph. As the facts would speak for themselves, the appropriate reports for the petitioner for the purpose of seeking further enhancement is to challenge the award dated 23rd February 2026 before the prescribed forum. We see no ground to entertain to initiate the contempt proceedings in which the respondent authority. The petitioner, commercial advice, may challenge the award dated 23rd February 26 before the appropriate forum.
Yes, we can taken to be serious.
The spent by the
I'm appearing in 36.1.
pursuing the instant petition may be directed for the purpose of communication. आपने देखा है सब. Yes, Madam Pooja, what happened?
Yes, my lords. My lords, I'm appearing in 36. This is a Navy matter.
I'm appearing in 36.1. It's an army matter. So there's a little difference, but I'll, whatever. If she wants to do a case first, it's all right.
So, my lords, I am only relying upon, ma'am can do her first. That's
So,
okay. Ma'am, please.
This is an
Ma'am,
army
can you
officer, lady officer, who had put in 15.5 years. Because when she completed 14 years, the judgment of the High Court in Babita Punya was there. That judgment was not stayed. They were bound to give me permanent commission, but they told me we will not give you permanent commission since the matter is pending in the Supreme Court. Now, my lords, I'll show my lord the order which said, this court said there is no stay at all. But still they said you come on extension only. And they, after giving her extension, she worked for some time. And then they threw her to Kashmir with a 3-year-old daughter because they were against her that you are not wanting to take. Now, she says, all right, I will leave the service and go. They ask her to give an undertaking. She gives her undertaking. Within 1 month, she goes and says, now, please reinstate me. I will go there also. They don't take her. Now, this court, Milos, has given people who have done 14 years service without being considered for permanent commission, at least pension. I'm not today saying if they can give
that.
Milos, I'll show the judgment. Milos.
No, these are two separate matters.
Yes, but they are, I think, I'm not sure about her facts fully, but in my case.
So are you arguing this lieutenant,
I'm arguing for Lieutenant Colonel Ravneet. Yes, Milos. She's put in 15.5 years and within.
Ravneet case?
Milos, army.
Yes. You are arguing Ravneet case?
Ravneet case, Ravneet. Milos, I'm arguing that case. And Milos, my submission is if they don't implement the judgment of this court.
After 2019, what action did you take?
Milos, 30th January 20, I was before them, and 21, I had filed my OA also. My OA remained pending. In fact, when my lord's judgment came, my matter was pending. In fact, we had filed it. Just 1 second.
You are virtually asking deemed service for pension.
No, sorry, my lords.
In your matter.
Yes, my lords.
You are asking now.
My lords, if I may just, I am relying on the direction of Annie Nagaraja. My lords, I have extracted in my synopsis on page C Direction number 109.11. My lords, direction number 109.11, if I may read, it categorically stated that as a one-time measure.
Voluntary retirement.
No, my lords. I was there. My OA was pending. If my lords may see, my OA for grant of PC was pending from 2017. So as on Annie Nagraja, I was also in court. I'll show you my prayers. I'd asked for PC.
In fact, despite the judgment, they were not willing to give us. That's the problem. Despite the judgment not being
In
stayed.
fact, my lords, learned AFT has granted pension to my course-mates also. And my lords, if my lords will see 109.11 categorically stated that anybody who is present before the AFT or High Court will be granted pension. I was granted pension. I was in court since 2017. My OA was 2017, asking for permanent commission.
Please,
That's the word.
Obliged.
Lord, in item number 37 and 38, my lords, these matters pertains to the builder, buyer, and the bank agreement, the tripartite agreements, my lord. So these also needs to be tagged, my lord. Only, my lord, in item number 37. My lord, in only in item number 37.
Subvention clause in your case also.
My lord, then there's a tripartite agreement, my lord. So these are the other batches, my lord, and my lord, in tripartite agreement. My lord, in item 37, recovery proceeding is being initiated. So just on 37, be stated.
What happened to the builder is also in CRP?
Yes, my lord, CRP and the CVI investigation is also going on, my lord. In 37, my lord, stay with the recovery, my lords. In 37, the recovery proceeding is going against.
You have said that no court will be fulfilled.
I am so grateful, my lords. 38 also, my lord, the same. 37 and 38 both were the same matters.
Hello.
Grateful, my lords.
May it please, shocking situation where this section itself admittedly doesn't apply. If my lords will just have section 8 of the PMLA, it's very, very clear in terms what adjudication is. If I may read that, PMLA, section 8, on receipt of a complaint under subsection 5 of 5 or applications made on the so and so, if the adjudicating authority has reason to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime. That's it. These are the two triggers. If your lordship sees what is the appeal which came before the High Court, just see page 626. This is the stand of the ED itself. Page 626 for a minute. If I can just read para 10. This is their stand in their appeal regarding me. Because I am a bona fide third party purchaser, they admit that they have no case against me. This is their appeal, page 626, para 10. If I can just read that.
Value thereof.
That's the problem. Just if I can just show you. The only thing that they can proceed against,
Value thereof.
the money is sitting with the company. I am a bona fide third party purchaser. There are 75 flats that were put up for sale. Just para 10, page 626.
Matter where notice has been.
Well, very well.
Very well.
We should have taken a shortcut.
Mrs. Brunton Developers.
We don't want to excite ourselves. Lordship has an order. Well, this is incidentally a house I'm living in. This starts in 16 and the actual attachment takes place by the impugn order in 2025. I'm living for decades there.
Dr. Singh, the High Court has indicated certain aspects.
Well, anyway, your lordship will tag it will satisfy my lord.
Which are
Lordship will
required to be gone in.
Very well. Your lordship will tag it.
But I mean, just to satisfy the conscience of the court, at the very outset, we were told that I'll get a 1.25 crore discount, 1.4 crore discount if I pay upfront. So I paid everything upfront. And this is for 75 home buyers who did it, and you choose 6 or 7 to come again. I mean, what?
Your lordship may tag it. Only one thing is that status quo as of today. I'm living there for decades.
Yes.
Status quo as of today.
No. Okay.
Okay, you want to.
Like. Well, there's a delay which may be condoned 88 days because of the review we had in between. Well, I'll just give an undertaking. I won't create third-party rights because our High Court's judgment stands in the way. Because the attachment order was set aside by the PMLAT. The High Court's order effectively reverses that. I'm giving an undertaking. I won't create third-party rights. Your Lordship may just note that.
Even if you are in possession, sir.
Yes.
Even if there is an attachment, it's a symbolic attachment.
The problem is there are many other procedures. The official liquidator and the banks are coming after this property, after which there was on consent a sale deed which was issued in my favor. For the High Court, I just wanted your Lordship to see that paragraph, that para 10 of the appeal. Specifically, it's shocking that after that they can proceed against me. This is their stand. I'll just read it out. The provisional attachments were made on the premise of property equivalent to proceeds of crime.
Value thereof.
No, I know, but that value thereof has to be of the person accused. I'm not an accused. And it was never alleged at any stage that the respondent was involved in the crime.
Sakadana, that's why we said these are issues may go into utter notice because you had no enforceable right created by handing over money.
No, I'm sorry, my lords. I had the allotment that was granted to me.
At performance,
yes.
Payment of money, will it constitute a written agreement creating an interest in the property?
No.
That agreement comes into being after filing of
Section 8 only requires me to have a legitimate claim. That's all it requires. The execution of the sale deed came from a court's order which has become final and has not been challenged. Lordship may say status quo then. That's been condoned. I'm grateful.
May it please your Lordship. My Lords, in 40, my Lords, the judicial service recruitment rules in the state at page 16 always had two categories. One was, my Lords, direct recruits and the other was in service. The first category of direct recruits, your Lordships considered in all India judges.
Dr. Sandhi, if let us say a senior advocate's clerk says that I am having an LLB degree, so let me allow and take a judicial service exam because I am regularly associated with the senior advocate in assisting his briefs and papers. It's tough.
This is
judicial establishment may have a law degree. Will his working in the establishment be equivalent to a professional?
Your Lordships had never considered that question in all India judges. Now, these are categories of persons. For example, they could be registrars, there could be court officers.
As much as there could be a driver. As much as there could be a driver.
With a
as much as there could be someone else.
So, my Lords, categories have been carved out. Page 17 would answer your Lordship's question, my Lords. So your lordship's exact question is answered at page 17. The categories that were carved out, for example, in Karnataka, my lord, this has been a practice across the board. Clause 3 at page 17, no officer or official in service shall be eligible for appointment as civil judge unless they are working in the High Court and court subordinate in the following cadres. So deputy registrars and assistant registrars, section officers, stenographers, bench officers, and these are persons who have historically taken the exams and been appointed, my lords, to the judicial service.
CG, Shrestadar.
Shrestadars. Lords, this, your lordship.
That's what we said. Then why, Dr. Sondi, your clerk will not be permitted? If a Shrestadar is permitted, then a clerk, if he gets a law degree, he should also be permitted.
Your lordships in All India judges only considered the.
Deputy.
No, my lords, your lordships only considered in All India judges the recommendation of the Shetty Commission, whether it should be freshers or 3 years.
Dr. Singh, we would have understood your argument had not that experience of 3 years.
Yes.
As a lawyer,
please,
been incorporated in the last order of the All India Judges case. Now see how significantly it changes the pool. It is not only a degree, but also a particular experience.
Yes.
As a lawyer, which is equivalent to law officers in respect of
I'm grateful.
prosecutors, etc.
Now, my lords, a judgment writer who works with a High Court judge, let us say for 3 years, has a rich experience of their own. Your lordships carved out an exception.
Everyone is not Lord Ganesha.
Lords, your lord.
He is not an amanuensis.
Your lordships carved
out. A stenographer is not equivalent to an amanuensis.
Your lordships have carved out an exception. Kindly, my lords, bear with me. Your lordships have carved out an exception in the judgment, for example, for law clerks. Now, the experience of a law clerk is on the one hand, the experience of an officer in the High Court, my lord, stands in its own right.
Extend it to a Sherestadar with a law clerk.
So, therefore, now, my lords, the High Court order at P13, page 172, we challenged, my lords, the amendment. Because Maharashtra, for example, has continued to carve out separate categories. And I would request your lordships to settle this position because my lord's judgment is being interpreted differently by different states. When we challenged the amendment, my lords, in Karnataka, the learned single judge's order was that without prejudice, subject to outcome that I can only apply. No rights were created in my favor. I'm only requesting at this stage, because the cutoff date, my lords, have extended qua certain serving judicial officers by other orders that have been passed subsequently. The question would be considered, my lords, at your lordship's door or before the learned single judge. But at this stage, my lords, to shut out this entire pool who were historically always, my lords, applying and participating in these examinations. There are 6 papers. They have to write, my lords, very detailed papers. I have produced the exam material. Then they undergo a viva voce. And till your lordship's judgment, they were very much being recruited from this pool. As I pointed out, they were 2 separate feeders. So at this stage, I'm only requesting, my lords, that the learned single judge's order and the High Court very fairly submitted before the division bench that if my lords were to issue that direction, they will accommodate us. Finally, my lords, whether that rule.
Obviously, that every High Court will do that once we.
Yes, but here the division bench
state. What will be in the interest of the quality and standard of the judicial.
Quite so, my lords, quite so. Today, if a law clerk
permission given that interim order is an unreasoned order, just 4 lines.
Kindly come to the order, my lords. Your lords will find it's a balance.
172.
Yes, it makes 4 conditions, my lords. And
that are the conditions of the injunction.
Yes.
But why should the injunction prima facie case made out?
That was argued.
I understand,
my lords. Those reasons are.
It's in the nature of a legislative amendment.
Yes.
To rules.
I fully.
You are actually injuncting a rule.
I'm aware, my lords. Health for millions, your lordships have said there must be a higher threshold. I'm not at all, because I cannot make good that part of the order.
Correct.
But now that I'm very respectfully submitting, your lordship's direction in All India judges, and my lords are fully aware, carved out exceptions. For example, a law clerk. And your lordships would consider that because today, my lords, Maharashtra, may I show your lordships? After my lord's judgment, Maharashtra has continued a 2 feeder, my lords, recruitment process. If your lordships would like to have a glance, there are 2 categories. If my lords come to clause 7, I'm sorry we did not annex this with the paper book. We got it later. Clause 7, my lords. This is the 2026 advertisement. Category 1 is advocate with 3 years experience. Then, my lords, comes ministerial staff of the High Court, minimum 3 years of service with a degree in law. So each state has, my lords, understood your lordship's directions quite differently, and I can tell your lordships responsibly, the directions in All India judges really did not consider the question of in-service. They were not even heard. They have their own right, my lords, under 14 and 16 to be considered for public employment. My lords had only considered whether the fresher versus 3-year requirement, my lords, needs a change. And that underwent, my lords, in fact, a threefold change. 93, 2002, basis Shetty Commission report, and then back to 2025. And my lords have issued notice on clarification applications filed by other categories. At this stage, my lords, all that I am requesting is permit them to kindly apply, and then your lordships may either direct the High Court
before us.
Yes.
Various applications keep on coming. You file an application, there we will clarify it, and that to this extent you may be right that we need to introduce a uniform eligibility criteria.
Please. Your lordships may be pleased to
It should not
treat
vary
this.
from state to state.
Yes.
For that you file MA in that case.
Would my lords like to treat this as an application, my lords? Because I went to the High Court challenging the virus of the rule.
No, that will somehow.
This is where we are joining issue with you. The rules virus is not really in question. The rule has carved out its difference with regard to, and the classification appears to be a reason.
My lords, that would be tested before the High Court. Really, because we were never heard here.
Taken out, it has to be a modification prospectively.
Yes, but not a.
Relate back to a selection process.
I'm so grateful. But your lordships in the direction in All India judges never directed that other pool of in-service to be done away with, my lords. Your lordships did not direct in-service to be completely excluded.
Read it impliedly excluded.
That would be the question now, my lords. Why would
excluded?
My lords, a court
When-
officer,
when
for
there is
example.
a mandatory direction of experience and exceptions carved out in respect of certain categories who are law officers or law clerks, then all other by
My lords,
necessity.
today registrars.
Until and unless an MA is taken out, and as the Honorable Chief Justice indicates, we clarify and make it clear that these ministerial staff, may be a registrar and an assistant registrar, may be excluded. But look at the array of staff which is included in the Maharashtra rules. The
Karnataka
rule.
the old rule.
And very interestingly, the discrimination that I was pointing out is taken care of in the Maharashtra rule, where even a staff in the government pleader's office is permitted.
Is permitted. What fell
But
from
as
your
I said,
lordships,
that
I
why
see that.
your clerk will be excluded?
But my
He
lord,
has more experience in handling briefs and law
I would
reports
in fact,
than
I would welcome that.
junior lawyers.
Your lordships would welcome that diversity also to the, it's an
We
entry level
definitely
of.
do it, but prospectively, not in respect of this selection process.
My lords, I was,
There is no hostile discrimination here.
as far as I was concerned, my category of candidates hitherto were always considered. Your lordships never intended to exclude. I can understand my lords are now saying impliedly, but then your my lords.
It's impliedly. But you are right that maybe at the time when this order was being passed,
Yes.
it was not placed before the bench that there are other categories of persons who are feeder posts.
Quite so. And their experience in its own right is a rich experience. After all, registrars also, my lords, of course, with.
Never, but we indicate the wide array of staff.
Quite
which
so.
has been from the bench clerk till the registrar, whoever has a law degree.
So, my lords, while your lordships consider that, my lords could consider.
The file application in that case, MA, because the two honorable judges are still there, because that's a special bench.
Very well, my lords.
They come, they are with me in that special bench.
Quite so.
What kind of deliberations took place?
Augustine and
Brother-
I will do that with one indulgence from your lordships, lords. Please permit them to apply. Their outcome will always be subject. Your lordships will see the order of the single judge.
all these complicate selection procedures.
Lords, not at all. The High Court has fairly submitted that it would have no objections. Please see the conditions, my lords. I'm sure your lordships would find favor. After all, this was an outcome of your lordship's direction.
Able to say that they have no objection when the rule is amended already. They will have to.
Please have a look at 172, my lords. The 4 conditions imposed. Your lordships may reiterate. I'm showing the.
Even High Court won't be able to entertain an application contrary to rules.
I quite see, my lords. The condition imposed here was that I will not claim equities, that it will be without prejudice,
So
and
therefore the issue will be that whether the rule is bad in law, liable to be struck down.
That can only be done after the High Court had recorded they have a prima facie case made out of unconstitutionality or unfair exclusion.
or
Without observing that,
or one
permit
other
someone to take an examination
There would be
when
one-
they do not fall with the zone
My
of
lords, there would be
consideration.
there
is
would be
rewriting the rule.
There would be one other category in this case, which is whether at all your lordships intended by the directions in all India to exclude this category. That would not necessarily be an Article 14, my lords, or a legislative.
Correct. That is why we are saying it can only come, your right
From your lordships.
spring when you take out a clarification application and the order is.
Would my lords like to treat this petition as an MA, my lords, and tag it with the pending clarification petitions that are before your lordships? Those are already on your lordship's file.
Which?
My lords are considering a number of clarification applications. There is in fact a writ petition of one Bhumika Trust, 1110 of 2025. That is a writ petition. And there are, my lords, 2 or 3 clarification applications, which I will give the numbers to the court officer.
Because we might consider that what should be the criteria on, as we said, on pan-India basis.
Yeah.
That issue we might examine if you file an application or anyone else applies to it. We will not examine the viewpoint Maharashtra, the view taken Karnataka. We will see that what should be the approach
Please.
in a uniform pattern.
So would my lords be inclined to tag this and consider it
No,
even as an.
no.
My lords would like me to file a separate MA. My lords.
Some MA may file.
May I, my lords, beseech your lordships for some protective order. This is a legitimate expectation.
We can pass
Let them kindly apply. Even the examination schedule is not announced.
See, please appreciate, today it's not the question of our judgment or High Court judgment. Today your statutory rules have been amended.
There are 15 persons, my lords.
There is an embargo created under the rules. Unless that rule is found to be unconstitutional, struck down, how will you acquire eligibility?
My lords, short of that, as I submitted, your lordships would see whether the rule meets my lord's direction in all India. There are 15 persons. I am not requesting that this be an order in rem. These who had the benefit of the order before the learned single judge may be permitted to apply. The calendar, my friend, is for the High Court is yet to be announced. Exams have not yet been scheduled. I will apply and thereafter be in your lordship's hands in the MA, my lords.
No, we will not be able to pass this order in this proceeding. We will see that if so MA comes, what can be done.
Your lordships may kindly give me that liberty, my lords, then too.
Yes, we are not inclined to especially the different. Our liberty is granted to the petitioners or any other aggrieved person to one appropriate application in the pending proceedings where eligible to recruitment to judicial services, where the judgment in relation to the eligibility conditions for recruitment to judicial services was passed.
Excellent. The last date may be kept open, my lord. That was a direction my lords issued in the other matters to keep the last date open. That would inure to the benefit of all. It's not just me.
You're not showing anything yet.
I'll come back to you. Grateful.
Online discount.
May please, my lords. You know, I beg to appear for the petitioners in
Well, I'm being led by Senior Counsel Mr. J. Sabla. He's appearing for VC.
Just always a
Just so
Sir, please unmute. Sir, please, other device disconnect.
Lordship, Milords, am I audible?
Okay, sir.
Milords, item 41, multiple FIRs have been filed against us, Milords, in various states in respect of the same set of transactions.
Savla, we are not entertaining any of these petitions. We are.
May I just explain? Milords, these offences are covered under Banning Unregulated Deposit Scheme Act. Your Lordship is examining whether it is central agency, CBI, who will investigate. That issue is pending before my lords in a connected writ petition where my lords have already issued notice.
No,
that is what my friend has the order. That is criminal writ 47 of 2026.
Victims of the crime, not at your instance.
No, under the Act, there is an overriding provision under the Banning Unregulated Deposit Scheme Act. If your Lordship may have a look at the Act, my colleague will show the Act. Lord, there is an overriding provision.
Those offences under the Special Act are in addition to the code and BNS offences. So if investigation is done for the BNS offence, there is no lack of
No, your Lordship is right. Here also, if your Lordship will see the FIRs include provisions of BUDS, BUDS, that is the Banning Unregulated Deposit Scheme.
It will be filed under the BNS offences.
No, charge sheet will be filed. Kindly just see the provision of the Act, Milords. It's a central Act. And your Lordship is examining whether the CBI in such cases.
We accept your contention that the state police ought not to have investigated the BUDS Act offences.
Yes.
But we are not inclined to do a dovetailing of the FIR. If FIR has BNS offences and the state police has jurisdiction, very good. If a police report is filed under BUDS, to that extent it will be invalid, but it would be valid in respect of the other offences.
If your Lordship will see the provisions of the BUDS Act, there is an overriding provision. And the investigation.
It relates to the BUDS offences. It does not override.
The FIR also invokes BUDS provision. If I may just show the FIR, Milords, at least 2 out of 18 FIRs also include BUDS provision, that is a Depository Act. And Milords, for the same set of transactions.
Go to the High Court and ask for stay of those BUDS.
Milords, there are 10 states where FIRs have been filed, and same issue my lords are examining. Identical issue in writ petition number 47 of 26. Your Lordships have issued notice.
You are not inclined.
May I just request my colleague to hand over the order where my lords are examining the same issue?
Yes, that will be examined in due course. Don't worry.
Milords, as far as the petition is concerned, this will lead to multiplicity, and that is why the act was promulgated.
That grievance from the victim's end will be well taken, not from the accused. The accused you are talking.
Would your Lordship just consider, my lords, the provisions of the Act for a moment, my lords? If your Lordship will just see the provision, section 34, which has an overriding effect. And section 34 clearly says that it is a central.
Reiterate our contention about the overriding provision. It overrides to the extent of BUD offences, but not the BNS IPC offence.
Your Lordship is right. If your Lordship will just see the list of FIRs, which is annexed at P1. Your Lordship has the Act, my lords? What's that? Kindly just see the provision, my lords. It isn't just to my lords. I'm sorry, my lords, I'm not able to. Your Lordship's question, I'm not able to understand.
Mr. Saab, I've clearly indicated to you the overriding provisions do not take over the jurisdiction of the state police to investigate IPC offences.
Your Lordship is right, but kindly see the FIR filed in this case, my lords. The list is attached at P1.
At this stage, it may arise only if a police report is filed of offences along with BUDS Act. To that extent, the Buds Act offences may be excluded from the case. That's all. And with regard to multiplicity of FIRs, we are not impressed with regard to the inconvenience of the accused. That is something we may look into when only victims are inconvenienced.
Lord, same issue also came up before my lords in the matter of Olega Satyam. And Lord, if your lordship will just see the decision of Olega Satyam, where this court has authoritatively pronounced that repeated production warrants are not acceptable.
Production warrant is a different thing.
No, in respect of FIRs,
Salve, if production warrants are issued without application of mind or by the appropriate court having jurisdiction to do so, lacking jurisdiction to do so, the jurisdictional judges and the High Court can look into them. That's no reason for clubbing FIRs.
Your lordship is right. Olega Satyam is a case where
there is a clear difference between multiple offences of similar nature and FIRs emanating from one cause of action. One cause of action is one, let us say, like a defamation case, or a publication which is violative of 295A, 153, 10 FIRs throughout the country. We would be inclined to collect them. But if a modus operandi gives rise to repeated acts of cheating individuals throughout the country, each act of cheating and deprivation is an independent offense of similar nature. There we will not apply this parameter and collect all the FIRs.
Would the lordship only see page 20 for a moment?
Agency feels collection of evidence.
Page 20 for a moment, which is annexure P1, the list of FIRs and the provisions which are invoked.
It is not within the ambit of an accused to select his investigating agency. It's not within the ambit of the accused to select the convenient forum of adjudication or investigation.
May I just show the notes and then I leave it at that. If your lordship will just see page 20 for a moment of the writ petition, where the list is attached of the FIR along with the provisions which have been attracted. And if my lords were to see item 14, 17, 18, etc., clearly provisions of Buds Act also have been invoked.
We have seen section 30, it doesn't refer any right on you too.
My lords, if the offense pertains to deposit and it is registered in several states, then and it is of high magnitude, then it would be transferred to CBI and there will be one central investigating agency that will avoid unnecessary different findings, that will streamline the investigation. Otherwise, kindly see today in 10 different states, same set of transactions.
Pray for a specific investigating agency does not lie